Well, that's a series of cases set for oral argument. Is entitled the Estate of Taveah, Macey et al. Versus Aultman Hospital. Case numbers are 29512, 29521, 29522. We have a number of appellants. How would you like to divide up your time?
Your Honor, by agreement, I'll be presenting argument for all the defendants.
You will be. Okay.
Yes.
Thank you for the process. That makes it easier, so thank you. Each side, of course, will have 15 minutes to present the arguments. Appellant may reserve up to 5 minutes for rebuttal. Just let me know how much you will be reserving, and I'll try to give you some notice, although we do have the clock on the wall now. The court has read the briefs, and we are prepared to proceed.
Thank you, Your Honor. May it please the court. My name is Greg Rossi, and it is my privilege, along with Rocco Potenza and Doug Leake, to represent Akron Children's Hospital and its named employed physicians. Rich Milligan and Paul Pusateri are also here today on behalf of the Aultman defendants. For agreement, I will be presenting argument. The issue before this court is whether the trial court abused its discretion in this case when it ordered simultaneous expert identification and expert report production when such an order serves to 1. Require disclosure of privileged work product information and materials. 2. Is contrary to well-established principles regarding the burden of proof. And 3. Violates the defendant's procedural due process rights. In this case, in this medical malpractice case, the court conducted an initial pretrial status conference, at which time the trial court established expert discovery dates, including simultaneous expert report identification and subsequently simultaneous expert report production. In other words, the plaintiffs and the defense were ordered to identify experts on the same day and then produce their reports on the same day. One of the issues the court has asked us to address here is jurisdiction. This court has jurisdiction in this matter pursuant to Ohio Revised Code section 2505.02b4. Under prongs A and B of that subsection, this is a provisional remedy. It is a provisional remedy because it deals with privileged matters. Pursuant to the Supreme Court's decisions in Smith versus Chen, and then subsequently in Burnham versus the Cleveland Clinic, work product is deemed a privileged matter such that this is a provisional remedy. Under prong A, the court ordered us to produce work product information. Under prong B, there is no adequate or effective remedy in the event we were to wait until a final judgment in the trial court matter. The privileged materials, the work product that is the subject of this, relates to the production of expert reports. And in that regard, I would direct the court's attention to page 4 of the trial court's order, in which it denied the motions for protective order. In that order, the court said, even in the absence of any information about which alleged non-testifying expert must be shielded from identification, it is difficult to conceive how defendants can claim ignorance as to the claims and theories plaintiffs have asserted in this case. By the time expert disclosure is required, the defendants have received the following information: a complaint, an affidavit of merit, all fact discovery, and it lists out all the fact discovery. Additionally, and here's the critical part, defendants have any information which they have received in response to subpoenas and have certainly had the ability to consult with their clients, the medical professionals at issue herein. So what is the trial court saying in its order? Who has clients? Attorneys have clients. The trial court is saying you attorneys should have been able to figure out what the plaintiff's experts were going to say based on the factual discovery and based on the ability to consult with your clients, the defendants, to figure out the plaintiff's claims. In other words, you attorneys should have drawn mental impressions, opinions, and conclusions as to the evidence to formulate the potential theories of liability, then meet with your experts and have them write about those opinions and conclusions that you, attorney, have made in producing their expert reports. This definition is work product on its face. So potentially everything in the defense experts' reports, in this case, in any case in which this type of case management order is set forth, is work product. And for that reason alone, this order should not have stood. But it goes beyond that. And looking at the burden of proof, in Bruni versus Tatsuni, the case the court's very familiar with, the seminal case in Ohio, on the elements of a malpractice claim. In order to proceed with a malpractice claim, plaintiff must have evidence of deviation from standard of care and causation through expert testimony. Basic tort law in the state of Ohio. It is their burden of proof to present evidence to establish a prima facie case. That is why staggered expert report disclosure, one which provides plaintiffs first, or the party with the burden of proof first, and the other party, in this case the defense, 60 days, 90 days, whatever it is thereafter, is appropriate and fair. We directed the court to Cuyahoga County local rules which provide for this. We cited Lorain County, certainly a county within this court's jurisdiction that also has a local rule, almost verbatim to Cuyahoga County, that requires the party with the burden of proof to produce expert reports first. The trial court, in response, in its order, cited, I believe, 11 jurisdictions which it contended provide for, in their local rules, for simultaneous expert report disclosure. There is no specific language in any of those local rules providing for simultaneous expert report disclosure. And I would say, I've been doing this job for 29 years. I don't know of one other jurisdiction where I've been that orders simultaneous expert report production in a medical malpractice case.
Counsel, let me ask you this. It is my understanding from reading the briefs that in order to comply with the deadline and not have any potential experts excluded, that you, defense turned in, I want to see if I have this right, identified experts or identified and turned over reports?
Your Honor, we did both. We identified our experts and then we produced reports on the date of August 2nd when they were due. It's the same date the court issued its order denying the motion.
And you're arguing that's not moot because I guess there's a second round?
Correct, Your Honor. It's a very good point, very good question. Yes, we're not out of the woods yet on the defense side. There is a supplemental expert report deadline in February of next year, February 21, 2020. I think the trial court and plaintiffs try to posture that as though that is a benefit to the defense. It is not. It continues to put us at risk. They have 5 experts against 9 individually named defendants. They have multiple theories of negligence. They have multiple theories of causation. There is nothing to stop them from adding additional criticisms now or additional theories of causation. So we don't really know what that's going to be, and we're not sure if we need to produce supplemental reports as well. And if we do, it would be the same arguments, that we are now at risk again for disclosing work product information. This type of rule also violates their due process rights. We cited the court to the App.No case, which is a 10th District case, App.No versus Ohio Department of Commerce, which cites United States Supreme Court cases, a number of which are in our brief, including Matthews versus Eldridge from the United States Supreme Court. Obviously, under the 14th Amendment to the U.S. Constitution, Article 1 of the Ohio Constitution, a defendant has an opportunity to be heard. Within that right to a hearing, and this is a quote from the United States Supreme Court, quoted by App.No, the right to a hearing embraces not only the right to present evidence, but also a reasonable opportunity to know the claims of the opposing party and to meet them. And this type of order does not provide for that. What this becomes for the defense is a guessing game. You are left to guess what the plaintiff's experts will contend, both on standard of care and causation, and really damages. I mean, that's another part of it that really is not in this case, but we all have life care plans we see in these cases, those kind of things. We did not have that in this case, but this type of order puts us at risk for not knowing what the claims are. and not being able to understand the claims and to meet them. We cite the court to the Federal Rules of Civil Procedure as well. In the advisory notes, they talk about the party with the burden of proof proceeding first with their experts, and the party without the burden of proof responding to those claims. That is consistent with all these things we've been discussing, both in our briefs and today. Burden of proof, work product, due process.
Now, there was a proposed rule change, I believe.
There has.
Has that taken effect, and if so, what is the effect on this case?
I think, Your Honor, my understanding is that they're in the commentary stage of that. In other words, they're still open for comments, or perhaps the deadline for comments just recently closed. But yes, there is a proposed Ohio civil rule, which would be, as I understand it, very similar to these rules we're talking about, which require the party with the burden of proof to proceed first, and then the other party is given an opportunity on that issue to respond.
You're at 4 minutes and 53 seconds. I don't know how much time you wanted to reserve.
I'm sorry, I wanted to reserve 2 minutes.
2 minutes, okay, continue then.
So there's no question this court has jurisdiction. There's no question that this type of order is unfair to the defense and is prejudicial to the defense for the reasons we set forth in our briefing and in the argument today. That is that it requires disclosure of work product, that it forces the defense. The civil rules talk about, in work product, not permitting the other side to benefit from the industry and efforts of each other. But that's what this does. It alerts the plaintiffs potentially alerts the plaintiffs to areas where the defendants may have concerns, issues that may have come up before, or may not have come up before. So this is why this type of order is unfair, and it absolutely shifts the burden of proof from the plaintiff to the defense. So in this case as well, there was a question about mootness, and we do have this supplemental report date. The other thing I wanted to point out to the court, it's referenced in our briefing, but plaintiff's counsel has taken this order and now they've doubled down, because we have this simultaneous expert report date. They've inferred that now to mean that they can take experts out of order. Historically, in these cases, what we've done is the party with the burden of proof on an issue has presented their experts first for deposition, followed by the party without the burden thereafter in response. So in other words, in these malpractice cases, plaintiffs have always gone first. We on the defense have gone after with all of our experts. They are now requiring or requesting or demanding, however you want to say it, our experts out of order. And the trial court's going to let them do that. The trial court did not issue an order on that, but merely an email from the staff attorney saying we're going to permit the discovery to proceed as it's been requested and intended. So we're now taking this issue to another level. So the issue is not moved. To answer Judge Callahan's question.
Counsel, because you've been here before, you know that most of the times, if the case is reversed and remanded, it is for proceedings consistent with this opinion. Given the mootness argument that's out there, not that it would make any difference in this court's ultimate opinion, but what is your specific request that the appellate court do in this particular case?
Good question, Your Honor. We would ask that the court reverse the trial court ruling on the motion for protective order and remand this case to the trial court with an instruction to establish a new case management order that provides in the supplemental reporting that plaintiffs go first and then the defendants have 60 days thereafter to file or provide any supplemental reports they may have. We would also ask that this court would instruct the trial court to require the plaintiff's experts' depositions proceed first in their entirety, and then the defense experts. That would bring fairness to this situation, or some fairness. I'm sorry, Your Honor, is my time up?
Well, you've got 1 minute 18 seconds left.
Okay.
If you want to save it for rebuttal.
I do, yes. Thank you, Your Honor.
All right, counsel, you'll have 15 minutes.
Thank you, Your Honor. May it please the court. My name is Tom Ryan, and I am representing the appellees in this matter. who are the plaintiffs in the trial court level. This appeal should be dismissed for a few reasons. First, we believe there is no jurisdiction to hear this appeal because this appeal cannot provide a meaningful remedy to the appellants because they have disclosed the expert reports on August 2nd, 2019 of this year. We also believe that there's no jurisdiction because this case is untimely. There's an attempt to modify the case management order, which was filed over a year ago. From memory, the case management order was issued in late September 2018. Parties litigated for approximately a year before it was brought to the trial court attention that there was an issue with any of the complaints that are being presented here today.
So you're suggesting that during the initial pretrial, counsel or counsels for defense never had an issue with the simultaneous reports?
So my recollection of the phone call was a case management conference. The staff attorney suggested a set schedule. Defendants objected, asking for staggered expert reports. Plaintiffs said we would defer to the trial court's preference. We didn't argue either way. In any event, the court issued a case management order, and the parties proceeded for over 8 months under that case management order. If the issues that they are presenting today gave rise to the level that they say, they should do something about it timely, namely within the 30 days after that case management order is issued.
Counsel, is that case management conference telephonic? Is it in the record anywhere, what was stated? Was it on the record?
You mean,
Can we
is
see
it?
it?
There's no transcript of it, but
Thank
it's,
you.
I don't know if it's recorded.
Well,
We called into a conference line that's set up by the trial court, and I don't know if it's recorded. There's definitely not a transcript, but there is a documentation of the order that transpired out of that case management order. In regards to the jurisdiction, the appellants have cited to the Smith v. Chen case, and I would like just to present some factual background to that specific case because the Ohio Supreme Court found that there was no jurisdiction in that case. The Smith v. Chen matter was a medical malpractice that occurred in Franklin County, Court of Common Pleas. The plaintiff alleged spinal injuries occurring out of medical malpractice performed by Dr. Chen and a corporate defendant. At some point, a surveillance video was taken of the plaintiff. During the discovery proceedings, plaintiff and counsel found out there's a surveillance video out of your client. Plaintiff's counsel requested a copy of the surveillance video. Defense counsel said no, that's work product. There were subsequent filings. I believe it was a motion to compel that was granted by the trial court, and then it was appealed interlocutory to the 10th District Court of Appeals, similar to what has occurred here. The 10th District Court of Appeals stated that there was a final appealable order, but then affirmed the disclosure of the surveillance video. Defendants then appealed to the Ohio Supreme Court. Ohio Supreme Court took the case and stated there was never a final appealable order, so they vacated the 10th District Court of Appeals opinion, sent it back to the trial court consistent with the original motion to compel. In the specific opinion from Smith v. Chen, and the site, just so it's available, is 142 Ohio State 3rd 411. On page 413, the court states, for an order granting discovery of privileged matter to be a final order, an appellant must affirmatively establish that an immediate appeal is necessary in order to afford a meaningful and effective remedy. This burden falls on the party who knocks on the courthouse doors, asking for interlocutory relief. Rendering a judgment on the merits of this appeal would signal to litigants that if they are unhappy with discovery orders that might result in their losing the case, they can spend a few years appealing to the matter all the way up to this court without proving a real need to do so. The case that they are citing, I think, is instructive because there is not a real remedy that can be provided in this case. Consistent with their own holdings, I believe that this court should also remand or dismiss the matter, send it back to the trial court to proceed consistent with the present case management order. Similarly, we do believe that the issue is moot. The parties have exchanged expert reports. There was no effort by the appellants to protect any claim of privilege. There's nothing redacted. There's nothing that was submitted to the trial court under seal. There's no privilege log, and there was never an indication to plaintiff's counsel that privileged information was contained within the expert reports that were provided. If this case were to accept jurisdiction and believe that there was a final appeal order, we are in an odd situation that we believe that the court will comply with its appropriate discretion, but we never filed any motion. A part of me feels like we're here just defending the court's decision when we never really made an effort to get any privileged information or work product. That was never the intent of the plaintiffs. We have just complied with the trial court's order for the last over a year. There is a mention that somehow we are pursuing expert depositions out of order, and I would just like to explain where that arose. There are multiple experts on both sides. Plaintiffs had retained a cardiologist, a pediatric cardiologist that's in Los Angeles. Defendants have also retained an expert in Los Angeles that works at the same hospital as the plaintiff's counsel. We requested to take both those on one trip, so we've got to gather up everyone's schedule and go out to Los Angeles to take these depositions. We stated, let's take both of them at the same time, and they refused. Dates were provided that everyone was available. We scheduled plaintiff's expert cardiologist, the first date, followed by the second date being the defendant's, I think, pediatric surgeon. And when we brought this up to the court, we referred the court to, the trial court, to Civil Rule 26. And in the staff notes, Civil Rule 26 specifically states the sequence of timing discovery is that any party can take discovery at any point in time. There's no priority rule in Ohio. What Mr. Rossi is arguing is that they should have the opportunity to complete all of their discovery, followed by then the plaintiffs to take their opposing experts, the depositions of the defendant's experts. The staff notes from 1970 specifically stated that priority discovery is a federal problem caused by misinterpretation of the current federal rule. Under the priority theory, the first party who served his notices to take depositions had the right to conclude his depositions and perhaps all of discovery before another party had the right to begin his discovery. The Rule 26D specifically rejects the priority theory. In Ohio, the argument that they're making is not applicable. You can take depositions in any order. And from our view, it's for the convenience of all parties. If we're spending the time to go out to Los Angeles to take a deposition of one expert, we should take the second expert the following day. In regards to the appropriate standard of abuse of discretion, again, I'd like to note that there was never a privilege claim that was presented to the plaintiff. There was never a privilege log presented. Nothing was redacted. The prerequisites of Civil Rule 26C were not met, and that was also noted by the trial court's order. Prior to filing a motion for protective order, the parties must engage in meaningful discussions to see if there's anything that can occur to prevent court intervention. In this particular instance, that didn't occur. In as much as there is a claim for privilege, we still don't know where that's contained because expert reports were provided to the trial court under seal. There was no specific attempt to protect the privilege, even if one does exist. Again, we are in a little bit of a predicament that I feel we are protected. We are arguing on behalf of the court, a court's decision that we never specifically requested. We are just trying to litigate this matter pursuant to the case management and the pretrial procedure set forth by the trial court. If there are no further questions from the panel, I made the balance of my time and I'd ask that this appeal be sent back to the trial court for consistent with the trial court's present orders.
All right, no questions, so thank you for the argument. Counsel, you're down to 1 minute and 18 seconds.
Thank you. I'll do within that time frame.
All right.
First, in terms of the timeliness, The appeal and the requirement for notice of appeal was not triggered until the court ruled on the motion for protective order. We could not appeal from a case management order, as is suggested by plaintiff's counsel. We needed more than that. We needed the court to deny the motion for protective order in order to trigger the time frame within which we filed our appeal, which we did. In terms of the expert reports, the supplemental reports were not ordered by the court in the manner in which we're now proceeding until September of this year. This expert depot issue didn't come up until October of this year.
They would comply with the requirements of 26 concerning contacting the other side.
Well, Your Honor, we didn't put it in our brief, and when this was all going on, Mr. Potenzo and I telephoned Mr. Ryan and spoke with him on the phone and told him we expected the trial court would do this. He said, and it's his right, I'm not being critical of him, he said we would prefer to proceed as the trial court will suggest. We brought that up again during the telephone status conference with the judge's staff attorney. We said to Mr. Ryan again, would you please agree to 60 days for the defense? In other words, you get your reports, then we get 60 days. He said, I would prefer to proceed as the court is requesting of us and requiring of us in this case. We all noted, every one of us on that phone call noted an objection to what the court was doing.
In the record or not?
There's no record of that pretrial, Judge. There's no tape recording, there's no transcript. It was by telephone. I think we have put it in our briefing.
I know there was some...
We objected, yeah. We put in our motion for protective order, and we put in our appeal. We clearly objected to what the court was doing, and I don't think Mr. Ryan disagrees with that. I think that what he told the court today is consistent with what we're saying. We all objected to what the trial court was doing. The last thing I want to point out, I would direct the court to United States District Court case from California that we cited, Plumbers and Pipe Fitters Local 572 Pension Fund versus Cisco Systems. Similar case, plaintiffs were requesting simultaneous expert report disclosure. Here's the quote from the court. Plaintiffs would not be prejudiced by disclosing their expert reports first. Since plaintiffs have the burden of proof, plaintiffs have the burden of presenting the evidence first. Plaintiffs will have an opportunity to respond to defendants' expert reports in their own rebuttal reports, including theories relied upon by defendants' experts with respect to their affirmative defenses. The court finds it is, in this case, simultaneous expert disclosure would in fact prejudice the defendants. Hypothetically, if the court is to adopt plaintiffs' expert disclosures, defendants would have to respond to all of plaintiffs' possible theories of liability rather than focus on theories relied upon by plaintiffs' experts. This would result in a needless waste of resources. It's a very issue before this court today, and we would ask that the court hold similarly. Thank you.
Thank you,
Sir, are there any more questions?
I don't think so.
Okay, thank you.
Again, on this case, we want to thank the parties for coming down today and arguing this important issue. We'll take the matter under advisement, issue a decision in due course. You will each get a copy of the court's ultimate decision from the clerk of the courts, and the opinions are also posted on the Supreme Court of Ohio's website. Thank you both for excellent arguments, and have a good holiday season.
Thank you, you as well.